Honorable Chair, Excellencies, distinguished delegates, I'm honored to present to you my report HRC5849. Over the 39 years of the existence of this mandate, countless allegations have been received speaking specifically to the interrelatedness of the right to freedom of religion or belief and the prohibition of torture and other cruel, inhuman, or degrading treatment or punishment. I will henceforth shorten this to torture and ill treatment. Recognition of the interaction between both rights, where there has been any, has largely been confined to the questions of torture and ill treatment carried out in the name of religion or religious interpretations and the right to non-refoulement. While these concerns are indeed of enduring importance, there remain significant gaps and unexplored potentials of a deeper understanding of how both rights relate to each other. Indeed, cases received by this mandate beg questions as to the scope of the overlap between the two rights. It is to those gaps and the greater understanding of those unexplored potentials that this report seeks to contribute. Distinguished delegates, several consequences flow from the coexistence of these rights throughout the sources of public international law. The prohibition on torture and ill treatment is an absolute jus cogens norm of international custom, which impose erga omnes obligations on all states. So, if someone suffers torture or ill treatment by virtue of their religion or belief, this too constitutes a violation of a jus cogens norm. Under the ICCPR, both rights share the characteristic of non-derogability, even in times of public emergency. Cases involving potential violations of both rights invite consideration of both rights and indeed their interaction with one another. The Convention Against Torture considers torture as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for several purposes, including for any reason based on discrimination of any kind. Hence, this includes discrimination on the basis of religion or belief. State parties to the CAT Convention must therefore ensure the protection of individuals or communities that are especially at risk of torture or ill treatment by virtue of their religion or belief. In addition, different international and regional treaties invoke the importance of contextual factors in determining the classification of a given act as torture or other form of ill treatment. Those involved in the determination of torture and ill treatment must therefore understand the contextual religion or belief issues at stake in order to be able to define the severity of the pain inflicted on victims. A significant and underexplored point of intersection between both rights, which is explored in depth in the report, concerns the prohibition of coercion, which is common both to the CAT Convention as well as ICCPR Article 18.2. While not all forms of coercion reach the threshold of torture or ill treatment, all forms of torture inflicted on persons on the grounds of their religion or belief constitute coercion. Both prohibitions are absolute and do not permit any limitations whatsoever. Consequently, torture and ill treatment inflicted in order to coerce individuals to change or abandon their beliefs violate not just one, but two absolute rights. Regrettably, mandate practice and jurisprudence demonstrates the widespread nature of such coercion, both outside and within places of detention. Distinguished delegates, the Human Rights Committee has established that the use or threat of physical force or penal sanctions to compel believers or non-believers to adhere to their religious beliefs and congregations, to recant their religion or belief, or to convert, constitute coercion incompatible with Article 18.2. The crucial element is compulsion. No coercion to adhere, to recant, or to convert. Policies and practices which have the same intention or effect, such as those which perpetuate social and economic marginalization of religion or belief communities and systematic discrimination with impunity, can also amount to coercion. Coercion can be physical or psychological and mental. This report highlights a particularly insidious and harmful form of coercion outside places of detention, namely disrespect for burial rights and the destruction of cemeteries and places of burial. The relevant case law has tended to silo these acts as a violation of one right or the other. In fact, it implicates both. While freedom of religion or belief protects rituals and places of rest for the dead, this does not fully capture the mental distress that individuals face when these are violated. A broader understanding between both rights can provide a more holistic response to such violations, as evidenced in a commendable recent judgment by the Inter-American Court of Human Rights, Rio Negro Massacres versus Guatemala. Madam Vice President, in cases concerning coercion within places of detention, within places of deprivation of liberty, a holistic approach similarly leads to stronger and more accurate human rights outcomes. The right to freedom of religion or belief is not suspended for detained individuals. In fact, guidelines provide specific minimum standards on respect for freedom of religion or belief of persons deprived of liberty. International judicial and quasi-judicial bodies have tended to analyze violations only in light of freedom of religion or belief, without also considering the effect of such violations in a context of detention on the threshold of torture and ill treatment. In stark contrast to the number of such incidents reported to the mandate, there is a notable lack of jurisprudence on these matters. This reflects a lack of information available to persons deprived of their liberty and a lack of attention to this intersection. The same is true of aggravated ill treatment, which is tailored to degrade people on the basis of their religion or belief. That is, ill treatment aimed at specifically affecting someone due to their religion or belief. The relevant jurisprudence has typically focused on the act of torture itself, rather than its increased severity due to the purposive targeting of one's religion or belief. However, a few cases, both before the UN Human Rights Committee and regional bodies, have demonstrated that it is possible and preferable to take both rights into consideration, because by doing so, the remedies provided for victims become more tailored. Recognition of the interplay of both rights allows judges and independent experts to consider the specific obligations to prevent, investigate, and remedy such violations in accordance with their specific discriminatory characteristics, thereby lending itself to stronger remedial measures, including satisfaction and guarantees of non-repetition. Distinguished delegates, there is much work for states, regional human rights entities, and non-state actors to do. I call upon all actors concerned to step up their activities in this area and do far more to adequately recognize and address violations, and to develop effective preventative measures to end impunity. Among my recommendations, I urge states to guarantee the absolute prohibition of coercion upheld across both rights, including attempts to coercively change people's religion or belief, or forcing them to carry out religious or belief practices that go against their religion or belief. I similarly urge states to provide appropriate training and judicial exchanges to allow court personnel to explore how cases relating to both rights can be prosecuted and remedied, and how gaps in protection can be addressed. States must also guarantee that effective preventive measures are in place to ensure non-repetition of violations, including the halting of incommunicado detention, and to offer comprehensive redress, including restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. Madam Vice President, upon the invitation of the government, I visited Hungary from 7th to 17th October 2024 and wish to express my gratitude to the government for the cooperation extended. My reports on Hungary assesses freedom of thought, conscience, religion, or belief in light of international human rights standards and offers recommendations for addressing areas of concern. The report assesses the implications of the 2011 church law, which marked a major shift in the country's previous legal approach to religion or belief organizations, significantly reducing the number of officially recognized groups and limiting their legal rights. The church law was amended in 2018 in response to both domestic and international criticism, and a new four-tiered system was introduced, but those amendments have fallen short of addressing broader concerns about discrimination. During the visit, interlocutors in Hungary shared that they enjoy the freedom to have, adopt, and change religional belief, and that religional belief communities can worship, associate, and gather irrespective of whether they are recognized under the four-tier system or not. They did share a sense of confidence regarding a general sense of physical security, which is clearly welcome, but does not cover the full scope of freedom of religional belief and non-discrimination on the basis of religional belief. The report finds that hate speech and intolerance is prevalent in Hungarian society, including from public figures at the highest levels, and in social and traditional media. Such hate speech is directed at a range of religional belief minorities, both overtly and in coded speech, and against others, including Roma, Muslims, Jews, non-believers, and LGBTIQ+. The report also expands on the extensive delegation of public services to churches in Hungary and the many human rights implications that can ensue from this. These have been detailed in the report in relation to health services, schools, universities, care facilities, elderly homes, and other services. I call on the government of Hungary to take the necessary measures to implement the recommendations stemming from the visit and stand ready to support in every way. Thank you.